best I could talking to myself.
But direction of the wind can change also.
That's what I'm saying. Lest I change the direction of the wind. But Parliament made a law saying Union of India will consolidate and pursue the claims on behalf of all victims. If your Lordship is pleased to turn to volume 2, P7. I have one of the very short points to you.
Volume 2?
CP, volume 2, page 329. I am only going to assist your Lordship on 2 points which I need to assist. Was there a settlement? Yes. Suggestion is that this was something more than a settlement or less than an adjudication. And if so, on what basis is the settlement being challenged?
Salve, it was a settlement. I don't think any of us doubt it was a settlement. Yes, court prods. At times, court prods, there's no doubt about it. Day in, day out in trying to arrive at settlements. We may have played the local scenario, the court may have played a little more active role in trying to do so. In family matters, every day we do it. Sometimes the bench comes, they say, leave it to this. Okay, we say X amount is a settlement. You want to agree to it, you don't want to agree to it. And then they say, okay, we leave it to the court too.
There was a reason why your Lordships did that, because the district judge had passed a judicial law asking the parties to settle or explore a settlement. So the process had been started by a judicial law. And that carried its, there were 2 parallel themes which were running. While the settlement was going on, the district judge said, I can't wait and see people queue up like this. Something needs to be done. So he passed an interim saying peso, which both sides challenged in the High Court. High Court upheld the principle but scaled it.
Scaled it down, and then that came up to
that came up in appeal. So there were 2 parallel tracks running. Try and settle, and in the meanwhile pay. Those 2 were sort of coalesced here, where your Lordship said settle, if you can. The appeal was argued for weeks and weeks in Court 1 before Justice Patna, while there were also conversations happening about whether this can be settled, because this had to be not settled obviously at very high levels, at the top of the management of the private company and at the top of the government. It had very far-reaching implications. And that is what was done. So there was a settlement. Now, what has happened pursuant to that settlement? Your Lordship sees this one document so that the nature of the curative becomes clear. Page 329, P7. In the course of submission, various questions came up. Actually, what exactly is paid? Are there any claims outstanding? A lot of these matters are answered.
Yes.
The death figures are 5295. These are paid. Death transferred to injury 10,000, permanent disability 3,000, temporary disability 33,000, injury of severity 40,000, minor injuries 521, loss of livestock 233, loss of property 547, PSU 8, total number of cases 5,74,000, compensation paid 154856.
These are the figures given in the review application.
Curative application.
Curative. So this is how they paid 1548. Came back to your Lordships saying we still have 1,500 lying in the kitty. So pro rata compensation given. Now, what the curative petition tells your Lordship is page 150 of volume 1, the Lordship sees it side by side. Curative CP1, CP volume 1. The Lordship keeps this page open and compares the figures.
What page are you referring to?
150.
150.
150.
And if your lordship looks at D, column D, and compares it to the number of cases column at page 329, death 5295, permanent disability is actually 4902 as against 10,040. Sorry, permanent disability is 4902 as against 3199. Temporary disability is 35 as against 33. Utmost severity is the same, 42. Minor injuries, 521 to 527. It's not much of an increase. Loss of property, loss of livestock. It's not that what has been paid and what are the actual number of cases in the curative are dramatically different. What then are they claiming? They are saying compare the figures in D to the assumptions of 4th May 89. What we have assumed and what have actually transpired are different. Now, what had they assumed? They had assumed 3,000 deaths. It turned out to be 5295. They had assumed 30,000 permanent disability. It actually turned out to be 4,900. They had assumed 20,000 disability temporary. It turned out to be 35. Utmost severity was 2,000. It actually turned out to be 42. It's this 50,000 assumed. It became 5,27,000. Loss of property, 50,000 turned out to be 555. Loss of livestock, 50,000 assumed to be 230.
That even from the chart the attorney had given to us, where the figures were given, we had put to him the real issue is of the solace amount paid to the persons with minor injuries.
Not even that, that also has been paid.
No, paid it has, but this is where the figures rose.
The figures rose from what was assumed in 1989.
Yeah.
Now, the question of law, which your lordship have to consider in a curative, is if the Union of India, which was perfectly aware of the uncertainties of the situation, thought that that public interest would benefit by equitous of signing the settlement at 470 billion in a full and final settlement, can come back and say, if you knew that the permanent disabilities would be 500,000 instead of 50,000, you would never have signed this settlement. And assuming that is so, does that become a ground to set aside a settlement? Point number one. Point number two, can you add top up? Because Union is not saying set aside settlement. They did. At one time they did. Today they are not saying set aside. And this is the fundamental difference between the review and the curative. Let me not put to one side the question about the procedure which your lordships have put. The attorney has answered, nothing I can usefully add. On whether, without filing a review, a curative can be filed. It is not merely a matter of procedure. There was something more troublesome there. If the union had to file a review, it would have had to elect on whether it wants to continue with the settlement or whether it wants to discontinue the settlement. scrap the settlement and say, we don't care about the settlement. Start the suit.
So why would in a review they be required to say so?
But it's binary. Either you stay with the settlement.
No, that's the same thing today.
No, exactly. So they don't file a review.
Even in a review, they would have said, look, we don't want to disturb the settlement, top it up, as they're saying in the curative.
They didn't.
They did. As a fact, they did.
No, what happened is something very interesting. Because your Lordship know the background. The review petitions I'm not saying it may be that it's a technicality that the union representing the review petitioners did not itself file a review, but it came and supported a review, etc. So you may say, in that sense, broadly, the Hura test is satisfied. I'm going on that basis. Taking up time on it. But then that creates.
Salve, having heard the attorney for such a long period of time, we are not going to shut him out because the curative has not been
Exactly.
taken. So
I am wanting to point out something else. Your Lordship tells.
Mr. Salve, one more thing, please. This was a settlement in this court. Now review is filed. Review is granted. Now under Order 43, the grant of review is appealable, specifically as an order of court. Now, if you're going to shut him out on curative aspect, then it will lead to a very.
I'm not saying that. I'm not saying that. That's why I said.
that's what
I'm not addressing a lot.
we already indicated. We have flagged that issue, but on that,
No, that's why I said I
would
don't even
not
want
like to shut out the.
I only said I'm not going there. What I want to show my Lord is something.
To that extent, you are right.
What I do want to show my Lord is what exactly happened. To inform the court. Please turn to volume 6, additional documents filed by us. This is the review petition prayers.
You mentioned the review petition prayers were to set aside the settlement.
Yes, I want to say.
But that's the by the other
The
people.
union said we support the review.
But the union never argued that the settlement be set aside at any stage.
I remember right in the opening, a subject matter dear to my Lord Justice Karnataka and my heart came up, tax law. Because one of the first questions which came up was, having appropriated the money under a settlement, can you challenge the settlement? Then Attorney General, my guru, Mr. Sorabji said, we have not appropriated the money. He produced a copy of the finance bill. Because there was a question of taxability of the interest on the purpose. So a provision was introduced in the finance bill appropriating this money and saying it goes to the exchequer. So there'll be no interest. There'll be no tax on the interest. So we said this constitutes appropriation. So this issue was very much at large. And what the union asked for is not set out fortunately for us. As Justice Venkatachalaya said, because nobody was hurt, we didn't keep it in the traditional confines of a review. Like your lordships have heard this case much beyond the confines of a curative. Their lordships, in fact, said we will hear if the settlement has to be set aside. That is what was being heard. Because at page 1433, just to get the record straight. The Lordship read that rather poignant comment by Justice Rangnapisha. But it's very easy to say, go try the suit for those who have no stake. Those who know the realities of the uncertainty of litigation will never make that clear. Number one important factor in the chronology of events as they evolved in those days. The settlement was arrived at when the challenge to the validity of the act is still pending. So the settlement became a point of argument in the act challenge, in the virus case. And one of the points was raised by Mr. Shanti Bhushan, saying Order 23 Rule 3D principle should have been followed before entering into the settlement. Your Lordship say that we did not set aside that settlement. And it was in that context now a full discussion is done. Please notice at page 632 printed, page 70, para 77, because that order of 15 February has been read, reread, and beaten to death. Please just see, ma'am. The order of 15 February refers to written memorandum filed by both learned counsel. Then Marat starts the discussion from paragraph 106. One of the arguments was that this amount was composite for civil and criminal, and therefore it was for stifling prosecution, and therefore opposed to public policy. Your Lordships reject that. Your Lordships allow the Union to argue that point at para 108. But this point ends starting from para 115 and ending at para 122 at page 650. On a consideration of the matter, we hold that the doctrine of stifling prosecution is not attracted in the present case. About the unfairness hearing, which one? Yeah, sense of proportion. Now, Malad, two important things, please see. Page 120, page 652, para 127. Gives your Lordship a sense of what is the lay of the land at that time. We may at this stage have a brief look at the work of the medical evaluation and categorization of the health status of the affected persons carried out by the Directorate of Claims. It would appear that on 31st October 1990, please mark one of 639,793 claims have been filed. So that finally that 500,000 claims came to be accepted. Even in as early as October 90, there were already 600,000 claims. So they are in curative. If in review this was not considered good enough ground to knock the settlement sideways, this can be a curative, can't be a second bite to the cherry. Then it goes on to say it was stated that a considerably large number of claimants who were asked to appear did not turn up. Medical folders, total number of deaths had written so and so. Medical evaluation has shown so and so. Then a whole figure is given. Para 129 speaks of the latency period of toxic injuries that was in the mind of the court. And what is important? is the discussion from page 655, from para 130. I don't propose for that. I will finish quickly. I don't propose to read all these paras. There is a full discussion about whether you can have multiple actions sequentially.
Split trials for participants.
Split trials. And this whole the whole discussion goes on. And at para 134, this point is put to rest. But the petitioners say that in the process of evolving what is fair, reasonable, adequate, some of the elements of essential relevant to fairness and adequacy, such as provision for future medical surveillance and the likely future but unforeseen manifestation of toxic injury, having regard to the nature of the hazard, have not been kept in mind, and therefore please mark these words. The approval accorded to the settlement is on an incomplete criterion. But the UCC would say that the Union of India was aware of the possibility of such future manifestations of the effect and must be deemed to have kept those in mind at the time of settlement. But the point to emphasize is those who are not parties to the process of settlement are assailing the settlement on these grounds. In personal injury actions, the possibility of further aggravation of the condition and consequent aggravation are taken into account in the assessment of damages. The estimate of damages is a very delicate exercise requiring evaluation of many criteria, some of which may border on imponderable. And then the whole discussion goes on this. And it ends by saying, even if the award is a once for all determination, these aspects will be taken into account. And then, after discussing the fairness hearing principle, page 97, in our opinion, I'm showing this because one of the American jurisprudence have been.
What is the paragraph number?
I'm so sorry, para 140. The American principles, your lordships have said, will not apply. Para 140. In our opinion, the right of victims relating to Section 4 of the Act to express their views on proposed settlement does not contribute to a position analogous to that in the United States, in which fairness hearings are imperative, either on their global settlement. Section 4 of the Act, to which right is traceable, merely enjoins the Government of India to have due regard to the views expressed. The power of union under the Act to enter into a compromise is not necessarily confined to a situation where the suit came to be instituted on behalf of the victims. Statute enables Union of India to enter into a compromise even without a suit. The right of being heard and read into form and subject to its constitutionality has been upheld in Sahu, subjects the Union to a corresponding obligation. But the obligation doesn't envisage a procedure like the fairness hearing as in the condition precedent to a compromise that the Union of India may reach in a situation in which it may do not necessarily to a suit. Accordingly, contention G is answered. The whole settlement is not vitiated for the reason alone for want of a fairness hearing. Likewise, the settlement is not vitiated by reason of the absence of a reopener clause built into it. Now, one of your lordships have not been shown any statute which was overlooked by coming to this conclusion, or some binding judgment of this court to the contrary, which was missed. In saying in a curative, this is a big egregious error. Is correct.
No, whether contents of the Union of India that award this consent order should be set aside, settlement should be set aside. Is it recorded anywhere at the time of hearing in this judgment?
Yes, but the Union of India challenged this.
No, whether Union of India argued before the review court that the settlement should be set aside.
Yes, they did. In fact, they went to the extent of saying this is for stifling prosecution opposed to public policy. Set aside the whole settlement. In fact, para 142, it immediately answers what Madam Justice is putting today. Para 143, please see.
12 also.
Yes.
The stand of the Union of India and other petitioners is that even upon setting aside of the settlement, fund should not be allowed to be repaid.
Right.
So they clearly challenge. Now the question was, what happens to the money? Your lordships in 142.
Well,
05, you read out.
Para 12.
Yes.
In Chief Justice Mishra's
Yes.
judgment.
And Union of India, paragraph 9, sorry. Paragraph
9.
Nine.
Correct. Supported the stand.
Correct? Who have asked for a review. And in fact, one of the subject there to Mr. Vikraj, he wanted me to read a paragraph. Okay. The union was criticized. The union was criticized for running the stifling of prosecution point. Where your lordship said, we hold that the doctrine of stifling prosecution is not attracted in reaching the conclusion. You don't put out a consideration that Union of India would, under threat of prosecution, coerce UCC to pay 470 and apart. In the context of the Union of India, the plea lacks as much reality as any sense of proportion. In fact, the argument was interesting. It is bad because under threat of prosecution, UCC agreed to pay. Lordship said this argument is not only bad, it lacks sense of proportion because. But please see page 98, para H.
Para H.
Yes. This also, my lord, answers your lordship's point.
Right.
If your lordship sees para 3,
Right.
keep the money back till such time as the decree is passed in the suit. What they were saying is restitution, yes, we will keep it in trust to appropriate against any decree which may be made.
Suit should go back then.
Suit had to be tried. Page 661, para 146.
146.
Then one of the arguments was, may I read from 145. The learned Attorney General also sought to point out that UCC had subsequent to the settlement effected certain corporate and administrative changes, and without a full disclosure by the UCC of these changes and their effect on the interests of the claimants, the fund should not be permitted to be taken out of the court jurisdiction. However, Government of India also should not be free to appropriate or use the funds. We are not impressed by any of these contentions. It is not shown that the UCC brought in monies with any undue haste with a view to confronting Union of India with the fate accomplished. The records indicate a different complexion of the matter. The payment appears to have been expedited at the instance of the Union of India itself. Strictly speaking, no restitution in the sense of any funds obtained and appropriated by the Union required to be paid by the back arises. The funds brought in by UCC are deposited in the RBI.
Ultimately, court says that restitution will follow, but that safeguard should be maintained.
Correct. Well, that will be, but they said in any case,
Right.
it will be done.
Court says.
Because one very important thing your lordship say in 148, and this is the strength of our system. However serious the incident may have been, the rule of law, my lord, has to stand.
Yeah.
And in the middle of para 148, your lordship says it is the duty of the court to ensure no litigant goes back with the feeling that he was prejudiced by an act which he did on the faith of the court. That's a very important consideration. Then para 153, your lordship says, we are satisfied. I submit that there is no top-up issue. That's, I don't think I can assist your lordship anymore on this. There are a series of, I'm only staying it in 2 minutes. Series of affidavits filed. Series of affidavits starting with 1994, 1995, and ending as late as 2011, where the Union of India has opposed every single attempt to suggest that the settlement is inactive. Affidavit upon affidavit upon affidavit. Argument before your lordship says the settlement has become adequate because the rupee depreciated. Go back to 89 and compare. But that can't be a ground for top up. In the long and short of my submission.
So Salve, which are the pages of the affidavits where prior to curative?
Yes.
They keep saying that.
That's very important. May I very quickly show 4 or 5 pages and then I'm done.
Just give me the page numbers. That's all.
First is volume 9, 12 December 95.
That is your volume 9.
Yes, ma'am.
December
95. There's a,
What page is this?
yes, it starts at page 2149.
Okay.
Please just,
That's fine. Next.
yes, please just mark para 5 and 6.
Yeah.
Then, my lord, 2003, there is a 32 petition file in which your lordship direct disbursal, where this 1300 crore figure came in, the 1500 figure came in. That's only, my lord, for the record. Your lordship's order is at page 2067 of volume 8.
Mr. Salve,
Yes.
can you do me this favor ask the instructing counsel on
On a piece of paper.
Just give the.
There is a written submission which I am filing and which I am inviting your lordship not to waste your time reading, except maybe
Does it
to
have
assist you on these
No, no.
pages.
Does it have the paragraph number?
Yeah, it
That's all.
does. Beyond that, my lord, please don't waste your time reading it. I mean, it says nothing more. It says in 20 pages what I've said. 10 minutes to your lordship. And I don't think the matter requires.
I just need those instead of noting down, so that there's no easier to locate those. That's all.
Are you doing it? TDCC, we don't know. Copies, please hand over. Your lordship had asked us to file written notes. So this is that written note. What your lordship is looking for. Yes, it's a Roman 5, page 7 onwards. Extracts are given in page number. Put all of it. Yeah.
Thank you.
Not unless there's anything else I can say.
Thank you.
Since your lordships have not discharged the alternative board, I take leave.
Thank you.
And we ask you to approach and report one.